And we're going to start today with the United States Patent and Trademark Office publishing a notice in the Federal Register regarding whether or not artificial intelligences should be able to obtain patents. So, a little bit about the Federal Register in general. It is the official journal of the United States government. It is the place where they publish all sorts of notices regarding all kinds of things, upcoming rules, upcoming changes, requests for information. Basically, anything that any federal agency has done or doing is published in the Federal Register. This has been a daily journal of the United States federal government since 1935. So this is volume or year number 84. It is published every weekday except federal holidays. So this notice on August the 27th was the 166th working day of the year. And they start counting on page numbers per volume. So this appears on page number 44,889 in volume 84 of the Federal Register. And we're going to read what they have to say. The United States Patent and Trademark Office is interested in gathering information on patent-related issues regarding artificial intelligence inventions for the purpose of evaluating whether further examination guidance is needed to promote the reliability and predictability of patenting artificial intelligence inventions. To assist in gathering this information, the United States Patent and Trademark Office is publishing questions on artificial intelligence inventions to obtain written comments from the public. The questions are designed to cover a variety of topics from patent examination policy to whether new forms of intellectual property protection are needed. Written comments must be received on or before October the 11th, 2019. So if you have an official comment that you'd like to submit to the United States government on this matter, you have about a little bit more than a month to do it. Artificial intelligence is increasingly becoming important across a diverse spectrum of technologies and businesses. Because execution of artificial intelligence invariably requires some form of computer implementation, many of the patentability issues relating to computer-implemented inventions, that is, for example, software, are germane to discussions of artificial intelligence inventions. Artificial intelligence methods and systems vary in their technical implementation, but rely on a substantial level of development and training by inventors, developers, and system users. The United States Patent and Trademark Office has been examining artificial intelligence inventions for decades and issued guidance in many areas that necessarily relate to artificial intelligence inventions. Going forward, the United States Patent and Trademark Office would like to engage with the innovation community and experts in AI to determine whether further guidance is needed to promote the predictability and reliability of patenting such inventions and to ensure the appropriate patent protection incentives are in place to encourage further innovation in and around this crucial area. The USPTO seeks comments on patenting artificial intelligence inventions. The questions enumerated below are a preliminary guide to aid the USPTO in collecting relevant information to evaluate whether further guidance is needed and to assist in the development of any such guidance with respect to patenting artificial intelligence inventions. The questions should not be taken as an indication that the USPTO has taken a position or is predisposed to any particular views. USPTO welcomes comments from the public on any issues that they believe are relevant to this topic and is particularly interested in answers to the following questions, which means that you are not limited to these questions. These are meant as prompts, so you can comment as long as they're, related to the area. But here are the questions the USPTO came up with. Inventions that utilize AI, as well as inventions that are developed by AI, have commonly been referred to as AI inventions. What are the elements of an AI invention? For example, the problem to be addressed, application of AI, the structure of a database which AI will be trained and will act, the training of an algorithm on data, the algorithm itself, the results of AI invention through an automated process, the policies weights to be applied to data that affects the outcome of the results, and other elements. What are the different ways that a natural person can contribute to the conception of an AI invention and be eligible to be named as an inventor? For example, designing an algorithm and/or weighting adaptations, structuring the data on which the algorithm runs, running the algorithm on data and obtaining the results. Do current patent laws and regulations regarding inventorship need to be revised to take into account inventions where an entity or entities other than a natural person contributed to the conception of the invention? Should an entity or entities other than a natural person or company to which a natural person assigns an invention be able to own a patent on an AI invention? For example, should a company who trains an artificial intelligence process that creates the invention be able to be an owner? Are there any patent eligibility considerations unique to AI inventions? Are there any disclosure related considerations related to IE inventions? For example, under current practice, written description support for computer implemented inventions generally requires sufficient disclosure of an algorithm to be performed for a claim function such that a person of ordinary skill in the art can reasonably conclude that the inventor had possession of the claimed invention. Does there need to be a change in the level of detail an applicant must provide in order to comply with this written description requirement, particularly for deep learning systems that have large number of hidden layers with ways to evolve during the training or process without human intervention? So that's a really good question. When you're talking about what you need in terms of disclosure for an AI invention to enable a person of ordinary skill, what do you need? Because the whole point of a patent, it has to be described in such a way as to enable a person of ordinary skill to build it without undue experimentation. So when you have an AI that is creating this invention and the AI is creating it, how do you measure a person of ordinary skill? Because the AI is inventing it. How do you provide disclosure such that a person of ordinary skill can build this? And if we're talking about patents owned and created by other than natural persons, who is the person of ordinary skill? Are we still talking about humans or are we talking about AIs? So do we have to be able to teach an AI or not? That is like a whole nother level of complication here. Very interesting stuff. How can patents for AI inventions best comply with the enablement requirement, particularly given the degree and unpredictability of certain AI systems? Same idea. You have to provide something that enables a person of ordinary skill to build this. How do you do that? How does AI impact the person of ordinary skill in the art? If so, how? For example, should assessment of the level of ordinary skill in the art be reflected by a capability possessed by an AI? Are there any prior art considerations unique to AI inventions? Excellent question. Are there any forms of intellectual property protections that are needed for AI inventions, such as data protection? Are there any issues pertinent to patenting AI inventions that we should examine? Are there any relevant policies or practices from other major patent agencies that help may inform the USPTO's patent practices and development? So this was just issued by the Undersecretary for Commerce, Andrew Ianco, who is the head of the Patent Office, wondering what should we do about AI? And so that's the question. What should we do about that? And you can offer a comment on the record. You can issue it by postal mail and by webmail, and you must issue it before October the 11th, 2019. I will just note, as the USPTO will, that any comments you do offer are public comments for the record. So this is a legal thing that will go in a legal register and be published. So if you're going to contribute, I would suggest doing so with a bit of professionalism so that you won't, look like a moron.